Hello students, welcome to the English language classes. We are gonna discuss for CA Inter the past questions asked with regard to Contract Act and dealing with the contract of bailment. So bailment falls under chapter number 9 of the Contract Act and it comprises of two contracts, bailment and pledge. We're gonna talk about only the past questions asked with regard to bailment. This chapter is from 148 till 181 and you must know one thing, the bailment starts from section 148 till 171 and two more sections 180 and 181. The reason is the pledge part is from section 172 till 179 of that. So the past questions. The first question on our screen is November 2003 question. What happened? Sunil delivered his car to Mahesh for repairs. Mahesh completed the work but did not return the car. See, we do the duty of the bailee. As a bailee, you have to return the goods the moment purpose is accomplished. This is section 160. Otherwise, you are gonna be liable for the loss under section 161. So here what happened? Though Sunil repeatedly reminded Mahesh for the return of the car, but remember here the important point is you have completed the work, means the car is repaired. So in the meantime, a big fire occurred in the neighborhood and the car was destroyed. So obviously here bailee is gonna be liable because 160 says it is your duty to return the goods when the purpose is accomplished. Otherwise, if you won't return, 161 says you are gonna be liable for the loss. And in the class we have did a case on the same facts, the case of Shaw and Company versus Simon and Son. The facts are similar. Held, what will be the answer? As Mahesh has completed the work, did not return, so he is going to be liable for the loss. Next question, May 2005. A. Hire a carriage of B and agrees to pay 500 as hiring charges. Now the carriage is unsafe. See, we do section 150, whereby it is the duty of the bailer to disclose if there is any fault in the goods he has delivered or the dangerous nature of goods. So when the carriage is unsafe, though B is unaware of it. So here B is the bailer, he is unaware of it. But the point is you are charging some consideration. So this is a case of what? Non-gratuitous bailment. So there is no excuse to the bailer that he wasn't aware of that danger. So you're gonna be liable for that. And now Mr. A is injured and claims compensation. But B is refusing to pay. So discuss the liability of B, he is gonna be liable. And the facts of the problem are similar to the case of Hyman and wife versus Nye and Sons. Even you can quote this particular case as well. Obviously the section is 150 that you are bound to disclose the fault in the goods or which may expose the bailee to the extraordinary risk, or you may say the dangerous nature of goods. It's a carriage, so you are bound to tell. Next question, 2007 May. Examine whether it constitutes a bailment in the following cases. See, under section 148 we do bailment. Bailment is delivery. Bailment is delivery of goods from one person to another for a purpose. Now the point is, what is delivery? We do section 149, whereby we say delivery means transfer of possession, not mere custody. And bailment is not about transfer of ownership, it is simply about transfer of possession. Now V parks his car at a parking lot, locks it and keeps the keys with himself. So when you are parking your car at a parking lot, it's not a delivery. Why? Because delivery section 149, remember it is 148 talks about bailment and it uses the word delivery, but technically speaking we talk about delivery under section 149. So you can quote 149 as well. So it's not a question of a delivery over here. Why? Because you are keeping the keys with yourself. So it's a case of a mere custody. Parking lot owner has, or garage owner has, only the custody, not the possession. So it's not a delivery, thus it's not a bailment. Second question. The goods are seized by custom authorities. See, they are taxation authorities. If you have done any infringement of law, you have broken the law, obviously they are bound, your goods are bound to be seized by them. So the goods are taken by them, so that means it is a transfer of possession. So that means it's a delivery. When it is a delivery, obviously it's a bailment. So in the second part, yes, because the reason is possession is transferred. So you can quote section 148 along with 149 also, because these are suggested answers by the institute. So something can add a extra also. Now November 2008 question. M lends a sum of rupees 5,000 to B on the security of 2 shares of a company. The company issued further. So what you have done? You have taken a loan by giving shares as security. Now the company issued bonus shares. You returned the loan amount, but the bailee returns only the original shares. They are refusing to return the bonus shares. So see, we do here section 163. On the accomplishment of purpose, you have to return the goods with accretion, and bonus share is accretion. And the facts of this case are similar to the case of Standard Chartered Bank versus Custodian. So Mr. M will be bound to return the bonus shares as well. November 2014 question, straight away 1 mark question, correct or incorrect. So in these questions, take care, you must start your answer with correct or incorrect. But it says bailee has no right to mix the goods with his own goods without the consent of bailor. Absolutely correct. So this is correct as per section 155. November 2018 question, what are the rights available to finder of lost goods under section 168 and 169? See, finder of lost goods is subject to the duties of bailee, but he is having certain rights, and the rights are under section 168 and 169. 168 talks about 2 things. See, as a bailee, you have taken the goods of someone else, so you must have gone into a lot of trouble to preserve the goods for the safe custody. So in that scenario, whatever expenses you have incurred, you have the right to claim that. And for that, you even can sue. You cannot sue. Why you cannot sue? Because you are a finder of lost goods. You have taken the goods on your own will, that is voluntary. So for that expenses you cannot sue, but yes, for those expenses, if bailor refuses to pay, you can retain the goods. But can retain the good, that means you can exercise the right of what? Lien. And regarding if some reward is declared, here there are 2 things. You can sue also and have the right to retain the goods. So 2 important things over here. So this is something more superior right as compared to expenses. So here you can file suit also and can retain the goods as well. Now this is under section 168. Now going to section 169. In 169, as a finder, you can sell the goods, and you can sell the goods only when they are perishable in nature, and the expenses of the finder are at least 2/3 of the value of the goods, or even you can add certain points. The owner is untraceable or refuses to take back the goods. Again, November 2018 enter question. Amar bailed 50 kg of high quality sugar to Srijit. So here the word is his sugar is of high quality. Now what happened? Srijit is running a kirana shop and he promises to give rupees 200 at the time of taking back the goods bailed, because he has given his sugar to someone else for taking care of. He is gonna pay you 200. Now Srijit's employee is unaware of this, that this sugar belongs to someone else. So what he did? He mixed this high quality sugar with the sugar of Amar and packaged it for sale. Now the moment Amar came to aware of this, he asked for the return of his goods, but the problem is the goods are mixed. So sugar is mixed with another sugar of low brand. Now can they be separated? No, they cannot be. So under section 157, here the bailee is liable for the loss in the value of goods, because the goods are mixed without the consent of Mr. Bailor. So this is section 157. It is without the consent of bailor. So here it is impossible, because it's a sugar, you cannot segregate it. So you have to bear the loss in the value of the goods, because it's a high quality sugar. Next question, May 2019. What is the liability of bailee making an unauthorized use of goods? See, as a bailee, he is under the obligation, duty, not to make unauthorized use of goods. If you will make unauthorized use of goods, here the bailor has two rights. Under section 153 he can terminate the contract, and under section 154 he can claim damages for the loss. So here, so as I said, the liability is, we're gonna quote is section 154. You can claim damages for any loss done to you, or you may call it compensation. May 2019 question. November 2020 question actually. If the bailee does any act with regards to goods bailed inconsistent with the conditions of bailment, the contract of bailment is. Now see again, it's the same question on the inconsistent. So that means as a bailee you have made is unauthorized use of goods. It's a MCQ. So here we have done section 153. As a bailer you can terminate, you can cancel the contract. So it's your right, it's your discretion. So the best option is what? Option number C. The contract is voidable at the option of bailer, and the reason I have quoted is section 153. Next question. January 2021. Radhesham borrowed 50,000 from a bank on the security of gold under an agreement which contains a clause that the bank shall have a right of particular lien. See, we do lien. Lien means right to retain goods belonging to another, if in continuous possession till your legal dues are satisfied, you can keep the goods. So basically we do is, as a bank they have the general lien. So here the word confusing for the students always is particular lien. Why it is mentioned? Why? Because particular lien we talked under section 170 and general lien under section 171. Particular lien is available to service provider when you have rendered some services involving some skill and labor. So see here, you have taken a loan from the bank on the security of gold. So don't get baffled by the word particular lien. Just ignore it. Somehow it shall not have been mentioned in the question. But that's how the question is. So in the exam, if something like that comes, do not lose your heart. What do you know about the law? You attempt on those bases, because there may be some error even in the questions by ICI. So what happened? Radhesham thereafter, so see, he has already taken a secure loan by giving the gold as security. He has taken another unsecured loan from the bank, rupees 20,000 from the same bank. Now what he did? He repaid the entire secure loan. So you must know there are two loans. So the first loan was secured now and requested the bank to release the security, that is gold pledged. Bank decided to continue on the ground that until the unsecured loan is fully repaid, they are not going to repay it. So see, under section 171, firstly we say the general lien is available on account of general balance, and it is available to banker, factors, wharfinger, attorneys of high court and policy brokers. In the absence of contract to contrary, they can retain, means unless there is a separate contract, they can always retain as a security for a general balance of account on any goods paid to them. But no other person other than these have this right to keep the goods unless there is an express contract to that effect. Now section 171 empowers the banker with general right of lien in the absence of contract, whereby it is entitled to retain the goods belonging to another party till the dues are discharged. Hence, in the first instance, the banker under an agreement has a right of particular lien on the goods pledged with it against the first secure loan of 50,000, which has already been repaid by the Radhesham. Accordingly, bank's decision to continue the lien on the gold until the unsecured loan of 20,000, which is the second loan, is not valid. Now that is the interesting part comes, because what section 171 says, in the absence of contract to contrary, even when there is no express contract, the bank has the right to retain as security for the general balance of accounts any goods billed to them. Now here the ICI answer says no, they are not going to have. Rather, in their answer they have mentioned the word that it is a particular lien. So probably here institute is trying to say Particular means it's a specific contract only for one thing. So, this is the interpretation over here comes. So that's how the problem comes, some ambiguity develops, because under section 171, the bank should have got the security for the another loan also as on account of general balance. You can even see the quotation over here, in the absence of contract to contrary. So, but this is ICI answer and I can't help about it, right? So I have shared what exactly the law shall be and how the things are. So with this, the questions comes to an end on bailment.